So thank you for joining us for today's webinar. This is the first in a three-part webinar series, and today's topic is going to be managing your business assets from prenup to breakup. The next two parts of the series will be respectively using non-compete agreements to protect your business assets, which will be held on Tuesday, March 17th from 2 p.m. to 3 p.m. And then the third part in our series, protecting your prime subcontract or strategic relationships, will be held on Tuesday, April 14th, same time, 2 p.m. to 3 p.m. So my name is Dean Nordlinger, and I head up the firm's business and corporate practice. I'm joined today by my colleague, Paul Mangle, who's counsel and who is the lead attorney in our litigation group. Today's webinar is, in essence, an effort to promote best practices by presenting some important themes and some hypothetical scenarios that are really a distillation of various challenging client experiences, many of which Paul and I have worked on together. At the end of the presentation, we hope there'll be time for us to field a few questions, and to whatever extent there are questions that we can't get to at the end of the webinar, we will be more than happy to follow up with you individually thereafter.
For my part, everybody, I'd just like to say good afternoon and thanks for joining us. This is Paul Mangle, and Dean and I do work together, and hopefully if your owner's agreements and the operative documents are in good shape, you will not need to resort to the assistance of a litigator such as myself, except maybe on the front end in getting some advice on how to avoid having to work with folks like me. But and if you have someone like Dean at the helm drafting your agreements, we might not ever meet each other. But in any event, we're here to hopefully give you some guidance along those lines and be able to avoid litigation.
Right. So, okay. Thank you for that, Paul. So to begin with, I think we want to start with the thought or the theme that a good business owner's agreement equals good business planning. And just for reference purposes, when we're talking about a business owner's agreement, we're using that term generically to cover either a shareholders agreement for a corporation, an operating agreement for an LLC, or a partnership agreement for any kind of partnership that you may have formed. So just to get right into it, one thing we know, appreciate, and understand is that many owners succumb to the understandable temptation to conserve capital and spend it only on those things that will directly grow and develop the business. This approach, however, does come with a cost, and that is the failure to engage up front in some good business planning on important issues that would otherwise promote smoother sailing for the business. So an important but often overlooked component of good business planning is to prepare up front for the possible pitfalls and perils of going into business with others. And when it comes to dealing with disputes among business owners, as they say, an ounce of prevention, in our experience, is truly worth a pound of cure. So from our perspective, business owners should look to and utilize the company's owner's agreement as a form of prenuptial agreement to plan for and overcome disruptive events in the company's business life cycle. And discussing and addressing how these events will be handled is key to promoting stability and continuity of ownership. Disruptive events can lead to disputes among business owners and even litigation, and as you'll hear in some of our war stories, these unfortunately can and do often take a heavy toll on the company and its owners. So while a business can still be successful, certain differences in partners' beliefs and or their personalities may not be reconcilable. And in that scenario, perhaps one or more of the owners should stay in and one or more others should exit the company. And a good owner's agreement is even more important in small to mid-sized private companies and or closely held businesses for the fact that typically there are fewer owners, many if not all of whom are actively involved in the day-to-day operations of the company. So now let's shift over and talk about some of the key issues that an owner's agreement should address. And they, generally speaking, fall into one of three categories. The first of which is ownership and financial. And what we're really talking about there is specifying the ground rules for ownership and buyout rights. And as far as ownership rights go, the owner's agreement would specify the ground rules for ownership. And these ground rules might require ownership to be tied to, for example, active participation in the company's day-to-day operations, and detail when and under what circumstances the company or its owners might have the right to buy out an owner's stake in the company. And typically, buyout rights are triggered by any of the following events: an owner's death, disability, employment being terminated, or even an owner being expelled for bad acts. And when we talk about management and governance, there we're talking about specifying the ground rules for whether and how ownership and management are either consolidated, meaning go hand in hand, or whether there's some level of formal separation between those. Now that happens naturally, of course, in a corporation because ownership and management are formally separated, even though one or more of the shareholders may in fact be an officer or even a director of the company. In an LLC, the ownership and management, well, it may or may not be consolidated. So in an LLC, the operating agreement would specify whether the company is to be member managed, in which case ownership and management are hand in hand, or whether the company is to be manager managed, in which case there's a formal separation between ownership and management, such that one or more persons, whether it would be one or more of the owners or possibly non-owners, would manage the company's day-to-day business and operations and only bring a number of fundamental matters back to the members to be voted on and approved or rejected. So when we start talking about that, one of the important things to consider is whether the owner's agreement specifies that simple majority will be the rule, and whether there is to be any exception for supermajority or unanimous vote being required for what we typically refer to as fundamental matters. And examples of that would include, whether the company is going to go out and secure a significant line of credit with a bank, or undertake and obligate itself to some sort of office lease, 5-year lease with several $100,000. And also importantly is to look at the actual composition of the ownership. If, for example, you're in a scenario of 50-50 ownership or something basically like that, then you have what we call the potential for deadlock. And what we mean there is the fact that there may not be any one owner who has control or a tie-breaking vote such that the company could basically end up in a standstill position because there's not sufficient agreement or approval for what direction or action the company is to take or not take. Now the third bucket, transfer rights, is specifying the limitations on an owner's ability to sell or transfer his or her ownership interest in the company to a third party. Typically, more often than not, the company first and the other owners second would have what we call a right of first refusal to purchase an owner's stake in the company if that owner ever decided to sell it. The prevailing theme that we're really focused on here is that you have agreed to go into business with one or more other specific people, and you don't want to be stuck with one or more other business partners that you never anticipated, whether that would be due to an owner going off and selling his or her interest to a third party, or simply or sadly, one of the owners dying and their surviving spouse stepping into the shoes of that ownership interest.
Dean, you mentioned some of these items that would require the risk of being locked up 50-50 in a deadlock, or some of these bad acts that might be occurring that would prompt a desire to have a member leave. And I like your choice of the word prenup, because it really is analogous to a marriage situation. When you're dating and you think everything's going to be hunky-dory, and you get engaged and you're all hung up and caught up in the wonder of it all, in true love, you don't like to think about, well, should we do a prenup in case things go south? Nobody wants to think that way, and I wouldn't suggest that our listeners are that naive not to think that way. But as you know as well as I do, how many times people have come to us and said to us, we just didn't think it would go south.
Right.
And it does, and they haven't provided for it, and the next thing you know, $100,000 in legal fees later, they're splitting up the marriage, which is the business.
Yeah, no, that's a great point. Great point. So now we're going to shift and talk about some of these potential pitfalls of what we'll call the basic owner's agreement. So as Paul was just alluding to, many of these owner's agreements share a common but unfortunate element, and that is they will discuss and address certain standard disruptive events, if any, such as death, disability, but they don't delve into other even more disruptive and, in fact, more likely disruptive events that the company is likely to face, including an owner's unexpected decision to simply discontinue his or her involvement with the company to engage in unrelated pursuits, or, worse yet, at some point, one or more of the business owners not seeing eye to eye on fundamental matters that are going to materially affect the company's business and operations. So a typical owner's agreement, for example, will address basic management and membership provisions, such as designating certain people to be the managers. Again, it may or may not be the owners, to run and control the day-to-day business and operations, and provide for a right of first refusal to buy out a membership interest if a member were to die or become disabled. But what a basic owner's agreement really doesn't delve into is addressing the more complex issues, such as, and the legal term is disassociating or expelling a member for the company, for example, for bad acts. So, events that may give rise to disassociation include a party's serious breach of its member obligations to the company, or otherwise engaging in wrongful conduct that materially and adversely affects the company. And without a provision to address situations like these, the owner's agreement leaves the company and the owners at a decisive disadvantage in trying to handle and resolve disruptive events that could dramatically and negatively impact the company's success, or in fact its survival. So having laid that as the background, we are now going to go forward through a series of hypothetical scenarios like I referenced at the beginning, the purpose of which is to illustrate the value and importance of a well-drafted, comprehensive owner's agreement. And Dean is going to go through these hypotheticals, but they're hypothetical in name only. Believe me, we've had every one of these possible situations has walked in the door here and has resulted in many times protracted and expensive litigation. But I guess, and none of our listeners, I'm sure, are old enough to remember Dragnet, but I am. Right.
Dean isn't.
You're dating yourself a little bit.
And the names have not only been changed, but they'll be omitted to protect the innocent. But these are all real-life scenarios.
Yes. So our first hypothetical is what we'll call the business relationship that is soured. So in this scenario, several individuals have come together to form an LLC to perform government work. And when they form the LLC, as Paul was referencing earlier, they're all getting along well, and they just simply don't envision a time when they might not be on the same page. They just don't even foresee it. So therefore, the owners use a basic owner's agreement that doesn't provide for an orderly business divorce. So for several years, everything goes really well, the owners are getting along great, and the business is successful. However, after that, what does emerge is differences among the owners in terms of business development and corporate strategy. And these cracks slowly expand, and the relationships continue to deteriorate until the ownership strife is so pervasive that it really spills over and negatively impacts the company's profitability as well as employee morale. So in short, we're looking at a situation where ownership problems are actually threatening the company's survival. So the simple question is, okay, well, what can the owners do? And again, because the owners have used a basic agreement that didn't provide for disassociating and buying out a member, their options, sadly, are really limited. So the majority owners, for example, could terminate a minority member from the company and strip the minority owner of day-to-day participation in the company. But that's really only a partial solution, because without clear provisions in the operating agreement for disassociation and buyout rights that spell out, when and how the LLC or the majority members can remove a minority owner and buy out the interest, it's difficult, if not impossible, to completely remove and sever ties with the minority member. So when an owner's agreement doesn't provide express terms to address a situation like this, the default rules of the applicable state LLC Act are going to control and tell you what's possible. And as an example, in Virginia, owners can petition a court to judicially expel a member, right? And if successful, the process will remove the owner's management and operational rights, but what it will not do is force that owner to forfeit his economic rights in the company. All right, now that leaves the owners in a difficult position of a partial divorce with continuing financial obligations to each other. So the only way to completely sever ties would be to reach a negotiated buyout, which would be difficult depending on the level of acrimony and discord that exists between the owners. And frankly, the company and the remaining owners in that scenario are likely going to be forced to pay a premium, meaning above fair market value, to the owner that they want to make leave to get him or her to depart, because simply put, they have no obligation to leave. So you're going to have to really sweeten the offer to make them go.
So you can't even get the divorce, and you're paying business alimony?
Yeah.
Or you're paying a premium to try to get the spouse out of the house?
Yes. Well,
that's tough.
Yes. Yes. Yeah. Not speaking from personal experience, of course. So let's take a look now at this second hypothetical.
I'm sorry?
And this is what we call recruitment of new partners goes awry, and we're going to throw in some bad acts there too. So this is a situation where we have an individual who forms a company and devotes a substantial amount of her time and resources, along with several key employees, to grow the company into a successful government contracting firm with multi-million dollars of revenue. So feeling like the company has reached a plateau, the owner decides to bring in new partners to take the company to the next level. And to do so, the owner gives up some of her equity in the company to two different people. One, a longtime key employee, and an outsider who's brought in to handle business development. So in the owner's mind, what she has done is granted equity to these two people for valuable services they're going to provide currently and in the future. In other words, she's providing equity on what we'll call a compensatory basis to these people, with the not only the understanding but the requirement that these two people are going to be actively and continuously employed with the company. However, the fly in the ointment here is that what she fails to do is update her basic owner's agreement that was in effect at the time that she was the sole owner. So the problem arises when the owner realizes that her new partners are really not the cultural fit that she thought they would be, and that they really don't have the expertise she thought they would have to bring to the table and take the company to the next level. So as a result, she continues to be responsible for the lion's share of the company's business development operations, with their two new partners having delivered very little. And now we throw in the bad acts and make the tale even worse. What she doesn't realize is that this new person she brought in from the outside has misappropriated confidential information from his prior employer and used it in several projects the company has performed. And so now the new employee's former owner is suing the company for misuse of this confidential information. So again, like in the first scenario, the original owner, because of the way the agreement's drafted, well, the original owner can terminate, her bad acting partner, or in fact both partners, from active participation in the company's day-to-day operations. But again, it's a partial remedy, because the owner's agreement doesn't provide a clear and indisputable path for the owner to disassociate and force the other two owners to sell back their interests. So now that I've sort of spun up these not so happy tales, I'm going to ask Paul to jump in and discuss more specifically how things might unfold.
The litigators always seem to come in when things are unhappy.
Right. Yeah, that's true.
How is that? I guess if every agreement was drawn the way it should be, we'd be like the Maytag repairman, loneliest guys in town. But the remedies available depend on several factors, and of course, obviously, as we've been talking about, one is what have you provided for in the owner's agreement, and you can include multiple provisions that can control what remedies you will have at your fingertips to utilize, such as choice of law and choice of venue, and other provisions that allow you to take charge when some of these unfortunate factual scenarios unfold. And I'm going to talk a little bit later in more detail about some of these specific provisions that you can include to sort of be the architect of your own destiny in one of these unfortunate scenarios. But I would like to talk at first about some of the statutory provisions that are in place in various state codes that could be the default provisions that you would look to if your agreement is silent. And I'm going to look at it in the context of LLCs, because most states have an LLC act that would address these particular issues. For purposes of our practice, at least in this region, we primarily see the application of Maryland, District of Columbia, and Virginia law, but of course Delaware law plays into a lot of these scenarios, because Delaware law is the default go-to law in a lot of, as you know, in a lot of corporate scenarios and in LLCs. With regard to the specific state codes, the Delaware and the Maryland LLC Acts do not provide a means for disassociation or removal of members if the operating agreement that you prepared is silent. Virginia and D.C., on the other hand, both allow for judicial determination of disassociation in the circumstance where there's the sort of wrongdoing by a member that Dean has alluded to. So as dry as it may be, I want to at least give a brief summary of some of the applicable laws so that you know what you're signing yourself up for when you put in your agreement that the applicable law will be law of a certain jurisdiction. And of course, those of you in states, and I see we have participants from all over the place in different states other than these four that I've mentioned, should question whatever counsel they have involved in preparing their agreement as to what are the implications of applying a certain state's law, because frankly, irrespective of where you are necessarily doing your business, you may be able to cite to a different state's law if you think it benefits you and if everyone agrees to it. So with that said, with regard to Delaware statute, that statute doesn't have language that allows for the disassociation of a member other than unless you provide for it in your operating agreement. The statute, for example, provides that an agreement can specify specific consequences for a member's failure to comply with the agreement, and it also allows a judge to determine the result of any vote of the members or managers upon matters as to which the members or managers have the right to vote pursuant to the LLC agreement or other agreement of the chapter. But the Delaware Code explicitly limits members from resigning prior to dissolution unless the agreement provides otherwise. So if your agreement is silent as to resignation and you've agreed to utilize Delaware law, then you are stuck and there's no provision for resignation other than dissolution under the Delaware Code. Under Maryland law, it differs than Delaware's LLC Act. Maryland allows members to withdraw prior to a dissolution upon 6 months' notice, and the Act also provides a laundry list of occurrences, some of which that you've heard Dean talk about already, upon which, quote, a person ceases to be a member, end quote, of the LLC. And these are such as bankruptcy, death, and I would suspect that that one might cause that person to cease to be a member of a lot of things, dissolution of the member entity, assignment of the member's economic interest in the LLC to someone else, withdrawal to another code section pursuant to the Maryland statute, or removal as a member in accordance with the operating agreement. So if you have followed the whatever procedures you've laid out in your operating agreement for removal of this member, as long as you have followed those procedures, you will have the blessing of the Maryland LLC Act. However, as with Delaware and Maryland, there's no provision for removal of a member if the operating agreement is silent. Looking at my home state now, the Commonwealth of Virginia, the Virginia LLC Act has a provision that's somewhat similar to Delaware's, and that allows an operating agreement to specify the consequences of a member's failure to comply with the agreement, which is what you want if your member has gone rogue on you. It also provides a list of occurrences similar to Maryland upon which a member is disassociated from the LLC. These include resignation, but again, that's if resignation is allowed in the operating agreement, so you need to remember to include that in the agreement if you want to rely upon that. An event that could be specified in the operating agreement as causing disassociation, such as the ones we just listed with regard to Maryland, death, bankruptcy, etc., assignment. And the member's expulsion, so the member can be expelled pursuant to the Articles of Organization if, importantly, you've laid those out. And I can tell you that Dean and I have been involved in litigation where the desire was to expel and the agreement was silent, and the owners come to us and say, what can I do? And sometimes we say, you're stuck, or sometimes we say, fortunately, you can, well, actually, unless you provide in the agreement, you generally are stuck. The expulsion can be by unanimous vote under the code of the other members if it's unlawful to carry on the business with that member, if there's some security or citizenship problem with that member, for example, or there's been an assignment or transfer of all or substantially all of that member's membership interest other than a transfer for security purposes, or a court order changing the member's interest, and that would be essentially an involuntary transfer. Another provision is expulsion by judicial determination, and that's on an application of an LLC, which essentially means by the LLC filing a lawsuit and putting it to the judge to decide, because, for example, the member engaged in wrongful conduct that adversely and materially affected the business. You can imagine that if you have a member that's engaging in conduct that, as Dean talked about earlier, that is adversely and materially affecting the business, you should have the right to go into court and seek the expulsion by a judge who will make that determination, because certainly your the entity or the person you're trying to expel is going to take issue that his or her behavior was wrongful to the extent that it adversely and materially affected the business. So that's going to have to be determined by an objective third party with the black robe on. Another example of expulsion is the member willfully or persistently committed a material breach of the articles of the organization or of the operating agreement, which is similar to, one would think that that would also lead to a material and adverse effect of the business as in the previous provision, or the member engaged in conduct relating to the business of the LLC, which makes it not reasonably practical to carry on the business with the member. As you know, if it's not reasonably practical to carry on the business of the LLC, it may be dissolved. This is analogous to that, and that is, we can't carry on with this guy here, and we need to get him out. But under the Virginia Act, the disassociated member continues to hold a membership interest and has the same rights that an assignee of the membership interest would have. In the District of Columbia, where we're now sitting, the D.C. Act provides for disassociation of a member in circumstances similar to what Virginia's Act does, and that is with voluntary withdrawal by a member, an occurrence of an event in the operating agreement that's listed in the agreement that would cause disassociation, such as the ones we've gone through a couple of times, death, bankruptcy, etc., expulsion pursuant to the operating agreement, similar to the Virginia provision, expulsion by the unanimous consent of the other members, which may be one person in an LLC or may be 20 members, if it's unlawful to carry on the company's activities and affairs with that person as a member, again, similar to Virginia's provision, if there's been a transfer of all of the person's transferable interest in the company other than for security purposes, or a charging order which has not been foreclosed, or the person is a corporation, LLC, or partnership that has itself dissolved. And again, as with Virginia, you can have expulsion by judicial order on application of the LLC, which means essentially by filing a lawsuit, because the person has engaged or is engaging in wrongful conduct that has adversely and materially affected or will adversely and materially affect the company's activities and affairs. So that is even a prospective adverse effect can be the reason for a lawsuit for expulsion, although that case might be difficult to make. A judicial expulsion can be granted because of willful or persistent committed or willfully and persistently committing a material breach of the operating agreement or the person's duties or obligations to the LLC, or that person member is engaged in or is engaging in conduct relating to the company's activities which make it not reasonably practicable to carry on the activities with the person as a member, again, similar to Virginia's statutory provision.
Yeah. You know, as you're going through that, Paul, I mean, the one thing that kind of occurs to me, because, you know, again, when we deal with clients, these situations come up, and we sit down, and the first order of business in the analysis with clients is, okay, well, you know, as they say, let's go to the videotape, and we got to go to the agreement. What do we have in the agreement that helps the cause that you're trying to advance? You know, or the exact opposite, stands in the way of the cause you're trying to advance, or perhaps in the middle is, well, there's not a lot there, so we have to figure out where there's room for interpretation because this agreement is silent. And as you said, you know, whatever you're not taking care of in the operating agreement, you know, to take best efforts to remove all doubt and detail a path that you would like to be followed, where the parties are agreeing in advance, this is the path that will be followed if these things happen. To whatever extent you decide not to do that, or your agreement comes up short on that, as you said, you know, the best case scenario is you're going to end up, right, perhaps in front of an arbitrator or in front of a judge. In other words, in front of some third party who is then going to have the task of doing some of their own interpretation, right? And that's where it becomes difficult, right?
Right, and as anybody that has been involved, hopefully our listeners have not been involved in extensive litigation, but if you've ever been involved in litigation or alternative dispute resolution, whether it's arbitration, mediation, the first thing that the person is going to tell you is, whether it's a judge in a conference or a mediator prior to undertaking the mediation, is, you folks really need to go out there and work this out, because you have been working together for 20 years. You know what you want from this business. You know what this business is all about. You know what your intentions are, and I'm sure you had good intentions going in. But I'm going to spend, 8 hours, or I'm going to spend 2 days, and there's no way that I'm going to be able to make a determination. I mean, I'm going to make a decision, and my decision is going to be final.
Right.
But you are in the best position to go out there and do what's best for this company. So I urge you to go out there and do it. And of course, one aspect of if you are in the position where you're putting it before one of these individuals is the enormous expense, especially if it goes the litigation route. I'm going to touch on a little bit later some of the options for dispute resolution briefly, but it really is the last resort to be in a situation where you're asking a third party to decide it, because it's a tremendously expensive enterprise. You may not like the decision that's rendered, but it is going to be a decision that's either going to be final in the case of an arbitration or subject to appeal in the case of litigation, and it's going to be tremendously taxing not only on the assets of the company, which may be paying the freight for both sides actually, and drawing down the assets, but it's also extremely taxing on the parties, and it's stressful. And it takes you away from what you got into this relationship in the first place, was to go out and make money. So it really is that ounce of prevention, pound of cure is a cliche, but it really could not be more applicable than it is in the situation with regard to these agreements, because the pound of cure is not only tremendously expensive, but painful in a lot of ways.
Sometimes not satisfying.
Exactly. And so with that in mind, what I'm going to move to now is another hypothetical where the former or departed owner is competing with the business, and tied in with that is the notion that this former or departing individual has information that is, the secret sauce of the company, or whether it's a client list, or a mode of doing business, or documents, and that are in their possession that you don't want them using. So I'm going to touch on, and this particular webinar is not sufficient in length to really each one of these avenues could be one or areas could be one that we could spend an entire webinar on, but I do want to touch on these provisions, because these are the kinds of provisions that you really need to think about and have your drafter incorporate carefully, and to avoid boilerplate, because these provisions will really serve to protect your company if it finds itself in such a situation. So there's no getting around the fact that attrition is just an inevitable fact of life in business, and it seems to us that in government contracting in particular. And when a departing either employee, but in our case co-owner, has been privy to your hard-won confidential and proprietary information, the thought of that information falling into the hands of a competitor has caused many a sleepless night for a business owner. And so there's some steps that a business owner can take to preserve and protect not only these assets. They could walk out the door these days on a thumb drive or a CD, or and deal with some of the non-competition aspects of this as well. So when you're preparing one of these agreements, you really need to have a strong confidentiality and non-disclosure and non-competition agreement. And these are really increasingly commonplace among parties entering into business relationships, especially it seems so with regard to the non-disclosure, given the high-tech revolution and how much data and information is easily available for becoming portable. So the language pertaining to non-compete and confidential information could be part of an owner's agreement or another agreement that sets forth these terms, as well as other terms such as compensation, benefits, etc. Or they could be standalone documents that are limited to an agreement to maintain confidentiality of a certain set of documents or information, and non-competition provisions. But whatever the case is, with regard to the non-disclosure provisions and the non-competes, as to non-disclosure, you need to lay out in the document in clear and unambiguous terms what the company considers proprietary and what the party is agreeing to do, and perhaps more importantly not to do going forward to preserve confidentiality of the data, and the penalties to which the party is agreeing to submit should that be breached, such as, and I'll talk about this a little bit later, but attorney's fees, damages, and injunctive relief. And there's been an explosion of litigation in these areas of the enforcement of non-competition and confidentiality agreements. And if there's a non-compete component of the agreement, and while, you know, when you're drafting this, the desire might be to make the non-competition provision as broad as possible, especially if you're leaving on bad terms. You might want to say, I don't want that. Not only do I not want him competing, I don't want him working anywhere for the next 10 years. That's the impulse, to make it as broad as possible. But any sort of non-competition provision is a restraint of trade, pure and simple. You're trying to put handcuffs on someone with their ability to earn a living, and courts don't like them in general. They're generally disfavored by courts because the presumption is that a person ought to have a right to go out and make a living. And so if you're trying to impede upon a former colleague's ability to do that and have a non-competition provision in your agreement, in order to be enforceable, it's got to be reasonable in duration. In other words, I don't want him working in tech anywhere in the world for 20 years. The duration has to be short. It has to be limited in geographical scope. You can't say anywhere in the world, anywhere in the United States, anywhere on the East Coast. I mean, the geographical scope is going to vary by region. For example, 10 miles in D.C., in the D.C. metro area, might be an unreasonable limitation given all the companies that are compressed in that 10-mile area, whereas 100 miles somewhere in the Midwest or elsewhere might be perfectly reasonable. So you have to limit the geographical scope, and it has to be tailored to prevent competition against the company, either as to the company's competitors or to the clients of the company for similar products or services that have been provided to the customer by the company in the past. And so it has to be limited. You can't prevent the departing party from going to work for a competitor in any capacity. For example, perhaps the competitor has a position as a janitor. If your agreement says that they can't work for ABC Corp in any capacity, that's not going to be enforceable. But you can, for a limited period of time, prevent him or her from working for the competitor in the same capacity that he or she worked for the company, your company. So each non-compete agreement is going to be analyzed by the courts under its own terms. Each circumstance is unique, and it's impossible for that reason to draft a one-size-fits-all document. So you need to avoid, and I don't know how many folks we've had come in the door that have done this, but I got it off the Internet. I got it off the Internet is 9 times out of 10 not going to be enforceable in the non-compete area because it's simply not tailored to the specific situation. So you must tailor each non-compete provision to the circumstances of the individual situation. They are addressed on a case-by-case basis, and generic boilerplate is just not going to cut it. And not only will it not cut it, but it will increase the chances of its unenforceability. So in addition to non-compete language and non-disclosure of company proprietary information language, the agreement could also contain such typical provisions as addressing the length of time the agreement will be in effect, and acknowledgement that irreparable harm will result if the information is disclosed. And that's an important element because in the absence of irreparable harm, you're not going to get injunctive relief. And an injunction being on the equity side of the court, Dean is not old enough to remember this, but when I started practicing actually in Virginia, the equity side of the court and the law side of the court were still separated. The equity side was hearkening back to the medieval days when you'd go meet in the courtyard and someone would say, well, he's diverted the river upstream, what are we going to do? That's not a law question. The chancellor would then put his chancellor hat on and say, well, let's dig a canal and you can both have the water. In other words, what they're trying to do is be Solomon-esque and be fair. And injunctive relief is always based on fairness and not the law. So you have to prove irreparable harm, and the court's going to be looking to a fair result. You could also mandate the return of the company of all the protected information. You could name the choice of law, and I'll touch on that a little bit later, and the venue for disputes. And you could put in a provision saying that if the departing owner violates the agreement and litigation results, he or she is going to be responsible for the attorney's fees incurred in the enforcement, and that can be a huge discouragement from a breach, and those are not oftentimes put in these boilerplate agreements. So irrespective of how well these agreements are drafted, some departing owners are going to simply convince themselves that they won't get caught, or they're going to be so anxious to assist in the new enterprise that they've gone to gain a competitive advantage that they're going to either disgorge the data or they're going to go ahead and breach the non-compete. So the question is, what can you do at that point to prevent or mitigate the resulting damage? Or if there's evidence of theft of confidential information, if you're concerned about that, then a well-drafted non-compete or confidentiality agreement is what you're going to need to get in front of the appropriate court to issue an injunction ordering the offending party to refrain from the use of the information, to return it, or not to work at whatever company that they've hooked up with that they're working with. So both federal and state courts alike have procedures for entering these sort of emergency restraints. They're usually called, in the initial phase, they're called temporary restraining orders. In other words, you run into court and say, Judge, we split this company up, or we bought out Joe X, he's got our secret information, he's about to use it, or he's working with someone and is competing with us, and we're going to have irreparable harm because once he shares that information, you can't put that toothpaste back in the tube. So you can, if you need be, you can run to court and get a TRO, a temporary restraining order. Those can sometimes be obtained the same day the court papers are filed, and they can be served on the parties and shut them down at that point in time. If they don't shut down at that point in time, they're in contempt of court, and then they'll have to face a judge and explain why they shouldn't be further punished. These injunctions are extraordinary remedies, as I said, and they usually require a showing that irreparable harm will result. In other words, money is not going to fix the problem. We are going to be irreparably harmed if this activity is allowed to continue or if this information gets out there. You usually also have to show that you're going to have a substantial likelihood of success on the merits, and that the injunction will be in the public interest. And as I said, the litigation process related to the nitty-gritty of TROs and the follow-up is a bit beyond the scope of this discussion. The point is that if you don't provide for this sort of relief in the agreement, then the odds of emergency relief being granted are significantly more remote. So you need to contemplate the need to do this, and you need to lay out in the agreement the path going forward if, in the unfortunate event that you're faced with a violation of a non-compete or the theft of proprietary information. And because you've worked too long and too hard to work on your trade secrets and your proprietary information to really risk it falling into the wrong hands, courtesy of your former owner. And the last thing you need is your former owner to undermine your success by immediately competing against you upon his or her departure. So you need to take the time on the front end of the relationship to enter into a really well-drafted non-compete and confidentiality agreement to protect the company. And again, nothing is going to be a guarantee that you're going to prevail, but as I said, if nothing else, they serve as a strong deterrent to the departing party and can be a significant aid in getting the judicial relief you're looking for.
Yeah, I just wanted to jump in for a second because you covered a lot of important points, and on this issue, right, putting in the protections in and around the non-compete, confidential information, similar to what we were talking about in the earlier two hypos, where, a lot of this, importantly, is what state am I in?
Absolutely.
Where am I, right? Because as we saw when we talked through the basic owner's agreement and the hypos, and these states, the LLCX, are different in terms of whether they are permissive and say, sure, you can take a run at a judicial disassociation, or that which you can in Virginia, but in Delaware it's a no-go. So you're bereft of anything. And likewise, it just struck me listening to you, with respect to the non-competes and having to have the proper restraints, and how, depending on what state you're in, a court may be a friend to you, or it may really just take your non-compete and throw it in the trash can.
That's exactly right, and which leads to another good point, Dean, and that is that certain states, such as Maryland, may take a blue pencil to the agreement and say, well, I'm going to rewrite this provision so it's fair. Whereas if Virginia believes that the agreement's unenforceable, or that provision of the agreement, it's gone. Now, if you have a severability clause in your agreement, presumably the rest of the document will survive. But some states, like you said, further to your point about choice of law, some states may modify that language to make it enforceable. Some states will say, nope, we're just going to take it out. And so you're stuck. So you really do. That's a good point. You need to consider not only the state, the choice of law, but also maybe the venue, whether you want to go to state or federal court, because sometimes states courts and federal courts might go different ways on affording this sort of relief.
Yeah.
So you've got to move along here, and I wanted to talk about some more general considerations that you would like to address. I touched on some of them a minute ago, and again, regretfully, we don't have enough time to really probe these, but there's a lot of information out there on each of these areas, but want to just advise you that you need to consider these sorts of issues going in so that you can control your destiny if things go south down the road, and your litigator will thank you when you come into his or her office with an agreement that has addressed these provisions thoughtfully, and it will save you money in the long run, believe me, if you put some thought into things such as dispute resolution, choice of law, construction rules, and then, of course, most importantly, attorney's fees provisions. So let's talk about litigation versus alternative dispute resolution. I'm going to shorthand it to ADR. Alternative dispute resolution can be, as I've mentioned earlier, arbitration, mediation, and the trend, it seems to me, over my career, the trend has been over the years for parties entering into contracts to have a default provision for ADR, some sort of ADR, usually arbitration rather than litigation. And I think the general wisdom has been that it's perhaps less expensive. And then the private sector, the government's even committed to ADR as a preferred method of conflict resolution in a lot of its forms. The ABA has observed that ADR is the preferred and likely outcome of disputes brought before the Armed Services and Civilian Boards of Contract Appeals, the Court of Federal Claims, and the Government Accountability Office. But you got to think about whether or not arbitration is the best choice for you. Theoretically, it can be less costly and time-consuming than litigation, but there's pros and cons to both sides that you really need to think about and not have arbitration be your default go-to provision. And I personally have found, in certain instances, arbitration to be equally as expensive. But some of the advantages of arbitration are that usually, with the exception of in the Eastern District of Virginia, which is known as the Rocket Docket, and in the Northern Virginia, I would say, region that has sort of adopted that philosophy, it can usually lead to a quicker resolution. That's one of the advantages of arbitration. Another aspect is that the parties can pick the fact finder from a list, so that you have more control of the process that you would in the courtroom. You can't pick your judge. One of the drawbacks, though, is that you've got to compensate. You've got to pay for the judge. You've got to pay for the arbitrator, I should say. And these fees can be substantial. Trust me, some of these arbitrators bill $500, $600, $700 an hour, and you are paying for that time for them to get up to speed on the case, whereas judges are free. And the federal court provides usually free mediators in the form of magistrate judges to help settle disputes. And as for the quickness, as I mentioned, some court systems are really known for their expediency. There are some courts that are backed up, but the nationwide trend has been to try to expedite cases. The Eastern District of Virginia is the leading court in that regard, known as the Rocket Docket. Your case is going to go to trial, and I don't care how complicated it is. If it's a patent case or it's a simple case, it's going to go to trial within 8 or 9 months in the Eastern District, period. So if the venue is something like that, then litigation, if you're concerned about expediency, might be the best choice. And people that want to delay arbitration can often do that. Whereas a judge keeps the parties pretty much close in check, arbitrators tend to go along with whatever you want to do. And one of the things I think is most risky about arbitration, and I speak from personal experience on this, is that no matter how strong a case you have, an arbitrator can make a decision, and I'm not trying to make a pun here, and it can be arbitrary. It can be completely arbitrary. It can be, in fact, counter to law. It can be completely at odds with the applicable law in the jurisdiction, and usually there's not a thing you can do about it, because most states have provisions that say if you've selected arbitration, you're stuck with it, and you can't go to the courts and appeal it. Now, you can provide in your agreement that the results of the arbitration can be taken to a court, but then you're paying twice for the same result, so people don't do that. So they tend to default to arbitration, and they don't realize when they do that they are stuck with that decision, and you can't go to a judge. And I am telling you, unless that arbitrator is stark raving mad, you're stuck with that decision, even if it's contrary to law. So you need to think about whether arbitration is the right thing for you. Another I don't know if you could tell from that, but I've had some experiences with arbitrators that were
you've had a few.
unfavorable. And it's very frustrating, too, because you may be right, but it doesn't matter because you're stuck with it. The other provisions you need to think about are choices of applicable law and venue. Way underemphasized, as we touched on the choice of law provisions that you need to think about, and you need to think about where you want to bring the action, which will definitely affect the outcome of the dispute. You can pick the law that you want to apply, and you can pick the place where you want to try the case. Another aspect is the construction of the agreement. If there's an ambiguity, the construction is usually drafted against the drafter, so you could put in a provision that states that the construction will be neutral in the event of a dispute. And, of course, importantly, the attorney's fees provision. I don't know how many folks have come in to us and said, you know, I want to sue this guy. Can I get my fees? The general rule in the United States is, the American rule, that is, everybody pays their own fees. And so if you need to sue your former partner, can you get your fees? Well, a lot of times it's not mentioned in one of these agreements, and it's too late after the fact. So if you don't provide for it, there will be no award of fees even if you win. So a loser pay provision can definitely influence not only the party's decision to litigate, but can drive a settlement in the event you have to go to court. But these provisions have to be carefully drafted in order to achieve the desired result.
Yeah, I was going to say, you know, I just wonder if you'd comment for a moment on the importance or the effect, as it were, of putting in what you and I would typically call as prevailing parties provision, which goes to the, so in other words, as you said, the general rule is, the American rule, everybody pays their own way,
right,
unless you put a provision in there that says, hey, loser pays. And so I think some people, and I think rightfully so, look at that provision, Paul, as a way to sort of level the playing field, meaning if one party, and I just want you to comment to the audience that, you know, if one party if both parties have to pay their own way, and that's just how it goes, somebody may have a slight enticement to behave badly, right? Because they may be saying to themselves, well, the other party is not as deep-pocketed as I am,
right? And
they're just going to have to lay down and be a lamb because they're not going to be able to fight me.
That's exactly right, and it does play into the positions that the parties take going in. One can be deep pockets, and one can be, I'm going to bring a frivolous claim to leverage because I know I don't have any exposure. So, right. So the attorney's fees provision levels the playing field in more than one way. It discourages one party from initiating some frivolous action that doesn't have a sound basis, because they know at the end of the day that you're going to be suffering as much as they are with regard to attorney's fees. But on the other hand, if you've got a prevailing party, if I win, you pay not only your fees but my fees.
Right.
The other side's going to think long and hard before they bring some sort of frivolous action to force you to take some sort of action you don't want to take, but because you have to roll over because you're afraid you're going to pay attorney's fees.
I mean, it's just a general nice deterrent against
Absolutely.
Bad behavior. Right. Okay. All right. Where are we? So I think we're getting close to the. Are we? You talked about that. Okay. I think we're kind of getting to the end of our time, and as part of that, and we, by the way, we do have questions, and I just want to say we're not going to have time to answer them on the call, but we have them logged, and we will. Those of you who have logged in questions, we will follow up with you individually post-webinar.
And there's a question from another listener about the last part of the feed cutting in and out, and will the recording be available? And yes, there will be a recording available on the website. I personally am not exactly sure how one gets there, but yeah, you go to PilieroMazza.com, and apparently you can access a recording of the seminar.
Yeah. So I think that the way we'd like to conclude, we've covered a lot of territory. We hope that you feel like we've shared thematically and by way of hypothetical illustrations some good information that you can take and digest offline as to how you might be able to incorporate into better practices going forward, or perhaps the good news is it's only affirmational for you because you already are engaged in best practices, and this is just your sanity check. But having said that, we do want to leave you with a few of what we'll call takeaways from today's webinar. 3, in fact. The first of which is the notion that the failure to plan in advance, unfortunately, can lend to a limited and incomplete set of solutions and remedies. Number 2, it may be wise, it may be a good time to review pull out your existing owner's agreement, to review it and see if it sufficiently addresses the most of your material concerns that you have about your current ownership structure and the way your business operates. And frankly, we work with a lot of clients in this area, and we do reviews of ownership agreements. And the last point would be that it's not too late to review and update your ownership agreement. The fact that you may have had one in place for years doesn't mean that you don't have an opportunity now to go back to the table with your co-owners and look at whether some sort of review and update makes sense, because ultimately it should be in the best interest not only of the company but the ownership generally. So with that, we're going to conclude. We thank you for your time today. As Paul mentioned, there will be a recording available, and we will follow up with you as to the individual questions that you posted during today's session. So thank you for joining us.
Thanks, folks.